Thank you very much, Glenn. It's my privilege and pleasure to welcome you all to the briefing this morning, the Washington Legal Foundation's briefing on the High Court at halftime. This is a briefing looking at the 2015 term at midpoint of cases that are pending before the court. Some have been argued, some have been briefed, some are awaiting decision. And it's really an effort to do an assessment of critical cases that are potentially having some impact on the regulatory, business, IP, and governmental power issues that face our economic system and our regulatory system and our free enterprise system. Today we're joined by three very talented Supreme Court practitioners and advocates, each of whom will do a series of cases and assess a series of cases pending before the court. Then we'll have an opportunity for questions from those of you in the audience and online, as well as perhaps have some commentary and comments from those who are serving on the panel regarding matters that were addressed by their colleagues. The first advocate who will be speaking this morning is Greg Katsas. Greg is a partner with Jones Day here in the Washington office for several years, from 2001 to 2009. He served at a variety of senior positions at the Department of Justice, notably as Assistant Attorney General for the Civil Division, and then as Acting Associate Attorney General of the United States. Prior to his service at Justice, he was a law clerk in the Supreme Court for Justice Thomas, and he had also clerked for Justice Thomas on the U.S. Court of Appeals for the D.C. Circuit. He is counsel of record in one of the cases which he will be discussing this morning, RJR Nabisco versus the European Union. After Greg, Melissa Arbus will address a series of issues and cases pending before the court. Melissa is a partner with Latham and Watkins here in Washington, and she's the local co-chair of the Litigation and Trial Department and a member of the firm's Supreme Court and Appellate Practice. She previously served for 5 years as Assistant to the Solicitor General of the United States, and she has also clerked on the Supreme Court for Justice John Paul Stevens and previously for Judge Motz on the Fourth Circuit. After Melissa, Ashley Parrish will address a series of issues regarding administrative law. Ashley is a partner with King and Spalding here in Washington. He's a member of the National Appellate and Strategic Counseling Group at the firm. Since Mr. Parrish joined the firm, its national appellate practice has been recognized by both Chambers USA and the Legal 500 as one of the top appellate groups in the country. Ashley previously clerked for Judge Garza in the Fifth Circuit. So I will leave it there. We welcome your questions and thoughts as we proceed through the briefing. And Greg, the floor is yours. So delighted you are here to join us.
Thank you. It's great to be here. I'll start with the RJR RICO case, which I've been living with for 5 or 6 years now. The question presented is whether the federal racketeering statute, RICO, applies extraterritorially outside the United States. And just as importantly, if it does not, what exactly it means for RICO to not be extraterritorial. The structure of the statute, there's a criminal prohibition which makes it illegal to engage in a pattern of racketeering engaged in connection with an enterprise. A pattern and enterprise are the two critical terms in the statute. Pattern just basically means 2 criminal acts in 10 years that are related, a pretty low bar. And an enterprise just means either a corporation or an association in fact, any conspiracy that has a degree of structure to it could be an enterprise. So 2 very broad statutory terms that define the crux of the criminal provision. And then in a separate section of RICO, there's a private right of action for anyone who's injured by reason of a violation of the criminal prohibition. Before I managed to lose this case in the Second Circuit, every single court that had ever considered this question after the Supreme Court's landmark extraterritoriality decision in Morrison had said that RICO has no extraterritorial application. And that sounds like a pretty categorical rule, but it just sets up the second question I mentioned, which is, well, what does it mean for RICO not to be extraterritorial? And there's a pretty deep split on that question, with one set of decisions saying that the pattern of racketeering activity has to occur inside the United States, and a competing set of cases saying that the enterprise impacted by the pattern has to be in the United States. Second Circuit disagrees with both of those decisions and says that RICO actually is extraterritorial, and what that means is that it extends to a pattern of racketeering activity outside the United States as long as the underlying criminal statutes extend outside the United States. And it turns out that some important RICO predicates do, most notably in our case, the money laundering statute. So that's a third position. And then we put into the case a fourth position, which is to say, forget about the criminal prohibition, focus on the private right of action. Ours is a private civil case, and we took the position that the injury to the private plaintiff has to occur inside the United States, regardless of whether the criminal prohibition reaches outside our borders or not. And we actually got the Solicitor General's office to support us on that point, notwithstanding their obvious interest in construing the criminal provision very broadly. They said when you're a private civil plaintiff, the injury has to have occurred in the United States. This is a pretty oddball case in many ways. It's been pending in the courts in one form or another for over 15 years, and we're still litigating the motion to dismiss. It's also an oddball case because the plaintiffs are a bunch of European governments. And usually in extraterritoriality cases, the people who are protesting most loudly against extraterritorial application of US law to things that happen abroad, and usually in the cases that means things that happen in Europe, people protesting most loudly are the European governments saying, no, don't apply your antitrust law or your securities law to stuff that happens in our country. We have our own laws. This is an infringement on our own sovereignty. Here they are not only advocating extraterritorial application, they are the parties invoking it, which is pretty ironic, as Judge Cabranes explained below. It's also odd in that the allegations in this case have evolved somewhat over time as the European governments have run into one after another problem. This started as a case in which the allegations were that Reynolds and other cigarette companies were engaged in smuggling, which caused the European governments to lose tax revenue. And then they hit the wall on that theory when the courts below said foreign governments can't recover for sovereign injuries under the revenue rule and penal law rule, and lost tax revenue is obviously a sovereign injury. So then they reinvented their case into, instead of smuggling, money laundering, and instead of the sovereign injury of lost tax revenue, the competitive injuries that they claim to have suffered as competing sellers of cigarettes. So they had this interesting theory that Reynolds and cigarette companies launder money. They sell cigarettes to in exchange for drug proceeds. So the cycle that they describe begins with drug dealers who sell drugs in Europe and take those funds and sell the funds to currency brokers who sell the funds to cigarette importers who sell the funds to Reynolds. Reynolds provides what they call a money laundering service. This gives them a competitive advantage. The competitive advantage is passed on through a bunch of markets so that when Reynolds exports cigarettes for competition in Europe, they gain the competitive advantage, and the European cigarette monopolies who compete against Reynolds lose sales as a result. If you think there may be a proximate cause issue in this case, you are right, but that's not what the court took up. They have made these allegations against every international cigarette manufacturer, and they have done very well, having settled against every defendant except Reynolds for something on the order of $2 billion. This is an ideal case to test the geographic scope of RICO, precisely because there's so much extraterritorial conduct. The money laundering, a lot of the money laundering is alleged to have occurred in South America. The allegation is that Reynolds sent people surreptitiously into South America to do these illicit sales there. The principal enterprise that's described in the complaint is this association, in fact, of the drug dealers who are in South America and Europe, and the money brokers who were in Europe, and the importers who were in Europe, largely foreign focused. We said that was a foreign enterprise. The district court agreed with us, and the Second Circuit didn't disagree. So as the case comes up, you have foreign conduct, foreign enterprise, and of course foreign injury, because if the cigarette companies are losing sales in Europe, that's a foreign injury. This is less critical to our theory, but the plaintiffs are foreign governments, and while Reynolds is a domestic defendant, the theory adopted below would apply just as much if the defendant had been a foreign defendant. So you have, as we describe it, not just foreign cubed cases by analogy to Morrison. This would actually, on our facts, is foreign to the fourth, and under the rule adopted could be foreign to the fifth. And I think reasonable people could disagree about the precise geographic scope and exactly what does or doesn't have to be domestic. But our basic position, reduced to one sentence, is however far RICO goes, doesn't go this far. We're teed up for argument at the end of March, and look forward to that. Next case, McDonnell. This is a public corruption case involving the conviction against former Virginia Governor McDonnell for honest services fraud, basically. Governor McDonnell took, perhaps unwisely, huge amounts of money from one particular donor. This was perfectly lawful under Virginia law, the Virginia law to which he was subject. And in return, the donor got the kinds of courtesies and access one would expect large donors to get. He gets invited to the governor's mansion for functions there. He gets meetings with staff so that he can pitch this product that he's pitching. But it's undisputed that he doesn't get anything official from the government. He doesn't get the government contract that he's after, and the testimony, which the government doesn't dispute, is that McDonnell sets up the meeting and then never instructs the underlings to give him the contract, never pressures them to give him the contract, and he never gets the contract. So the crux of the case is what counts as an official act sufficient to support a public corruption charge. If there's an official act involved, the quid pro quo is illegal, getting the official act in exchange for the contribution. If it's not an official act, then it's not illegal even if there is a quid pro quo. And the case basically turns on what counts as an official act. Our position, it's another Jones Day case, it's not mine, but our position is that an official act is a formal exercise of governmental power. He gets the government contract. he gets the investigation dismissed. He gets money from the government, something of that nature, as opposed to the government's theory, which is an official act, is sort of anything a government official does in his capacity because he's a government official. So when the governor invites you to the governor's mansion for a reception, well, he wouldn't be doing that if he wasn't the governor. So on the United States theory, that's an official act, and that supports the conviction, which, if you think about it, is really stunningly broad. So the donor gives the money. What does he get in return? He gets an invitation to the governor's mansion, the White House, and it's a quid pro quo. The reason he gets the invitation is he gives the money. On the government's theory, that's a felony. If you're a federal official, it's bribery. If you're a state official, it's honest services fraud. That seems incredibly broad. And seems to conflict with a lot of things the Supreme Court has said in related contexts, that when the President of the United States, for instance, invites the championship team to the White House and gets a jersey in return, right, that's not a felony. That's not bribery, and if the President does it, and it's not honest services fraud if the governor does it. Why is this of interest to business? Well, it's not only illegal for the government official to take the money in return for an official act, it's also illegal for the private party to give the money. So if you think of politics as usual, right, the party has a retreat, and if you give $10,000 or whatever, you get invited to the retreat and you get to meet some senators. Well, not only is every senator who goes to that meeting a federal felon, every donor who goes to that meeting is a federal felon. We think that's very troubling and probably not likely to be upheld. I'll just mention a couple of other cases more briefly, which aren't ours. Spokio argued, I think, in November. It's a question about Article 3 standing, and the basic issue is who controls the Article 3 standing gateway into federal court. Law is settled that you need an injury, a private party needs an injury to be able to sue in federal court, and the court uses words like discrete and particularized and injury in fact and legally cognizable injury, all these phrases as shorthand for what you need to get into federal court. And the question in this case is basically, does Congress control that, or do the courts control it? Is it a matter of federal constitutional law so that when the Supreme Court says this kind of injury doesn't qualify, it doesn't qualify? Or can Congress create Article 3 standing by passing a statute and saying, here's an injury, defining the injury that lets you get into court? It seems from the argument that they're not going to embrace probably the Ninth Circuit position. Ninth Circuit went whole hog on this, saying that Congress can create the injury, and that does a couple of pretty striking things. It, I think, collapses the distinction between standing and private right of action, and it eliminates any meaningful sense in which Article 3 injury is constitutional. If it's constitutional, one would think it's controlled by the courts, and under the Ninth Circuit view, it's totally controlled by Congress. Tyson Foods, this was potentially a big case. When it came up, two significant issues in the case. One is the extent to which plaintiffs can use statistical estimates to prove their case. This is building on the criticism of trial by formula from the Walmart case a couple of years ago. And the second question in the case is, does a class have to be defined to exclude anyone who wasn't injured? And this is sort of building on the idea that rigorous scrutiny of class certification builds in a lot of merits-like considerations, as exemplified by the Comcast case from a couple of years ago. This one really seemed to fizzle at the court. This came up in the context of the FLSA, Fair Labor Standards Act, and the court's reaction to the case was, well, there's a special non-Rule 23 procedural provision for FLSA cases, and there's a special damages rule for FLSA damages going back to a case from a bygone era in the 40s where the court said, well, these are plaintiffs and there's a broad remedial purpose, so we're not really going to make the plaintiffs prove damages with any rigor, and they can estimate these things. If that's your substantive rule of law, then there's not much of an argument that the class action is improperly redefining substantive law when it allows open-ended statistical estimates, because that is the underlying substantive law. And that was the court's reaction to it. Kennedy seemed strongly to say, well, this is just an FSLA case governed by those rules. And Roberts, of all people, seemed to want to take that precedent from the 40s and not only apply it, but extend it. So this is not likely to go well for businesses. That's the bad news for the WLF position. The good news for the WLF position is any bad decision for business is likely to be FLSA specific and not have broader consequences. Last case I had is Microsoft versus Baker. This was just granted, not yet briefed, so we don't have as many interesting things to say about it. But the question is the extent to which plaintiffs can take an immediate appeal from a denial of class certification. General rule is they have to wait until the end of the case under the statutory finality requirement. And there's a case called Coopers and Lybrand, which says that rule prohibits interlocutory appeals from denial of class certification. Here what happens is the plaintiffs get denied class certification, then they say, we're dismissing our claims, but then we're going to appeal the denial of class certification. And the petitioners, and the Ninth Circuit let them do that. The petitioners come in and make what seems to be a pretty compelling argument that, look, one of two things is the case. If the claims are supposed to spring back to life, if the dismissed claims spring back to life when and if the Court of Appeals reverses class certification, that's just an obvious end run around the decision that says you can't take up the class certification before you litigate the merits. On the other hand, if the named plaintiff's claims really are dead once and for all, forever, then it sure looks like it's a moot appeal when the named plaintiffs whose claims are dismissed try to go up on a procedural issue. Let me stop there and turn the floor over.
Okay. Melissa?
Thank you. Thanks for having me. Good morning. I'm going to start a little bit where Greg left off and talk about another class action case from this term that was decided already, the Campbell-Ewald case. Full disclosure at the beginning that Latham represented Campbell-Ewald, and I was on the briefs. In that case, it was argued earlier in the term. It was decided just this past month. So technically, this one was a win for class action plaintiffs, but I say technically because, as I'll discuss in a little bit, I think there's a pretty large silver lining in the case for the defense bar. Some background on the case first. It's a TCPA case involving the Telephone Consumer Protection Act, which basically has certain rules that govern telemarketing. Importantly, it provides for statutory damages of about $500, I think maximum $500 per violation, which with respect to an individual case is not a terribly huge amount of damages, but with respect to a class action can be pretty astronomical. And there are a lot of these cases because there's potentially great exposure. In this case, it involved a text message. The Navy had hired Campbell-Ewald to do a marketing campaign for it, and as a part of the marketing campaign, Campbell-Ewald, through a subcontractor, was sending out text messages to individuals, recruiting them to join the service. Now, the text messages per the TCPA were only supposed to go to individuals on an opt-in list. The allegations in the case were that, at least with respect to Mr. Gomez, that they came to him. It was unwanted. He was not on the opt-in list, and so there was a violation of the TCPA. So he filed suit. He filed it as a putative class action. Before it ever came to that, Campbell-Ewald came in and said, listen, we'll give you everything you're asking for, we'll give you maximum statutory damages for each violation, we'll consent to an injunction, et cetera. And he said, no thanks, I'm good, I'm gonna go forward with my claim. And so Campbell-Ewald said, well, you can't anymore, we've given you everything you've asked for, there's no case or controversy to go forward with, the case is moot, it needs to be dismissed. There was a second argument in the case, which I'll talk about as well, saying, even if we're not right about that, we were acting under a government contract, we're entitled to what's called derivative sovereign immunity, and so the case should go away for that reason. As well, it made its way up to the court through the Ninth Circuit in that posture, and this is not the first time the court saw the first issue. I'm going to start with the mootness issue because that one has gotten by far the most attention, I would say, in the court certainly, in the press, and with the bar at large. And that is, if you offer complete relief, does that moot an individual plaintiff's claim? There was a second issue that the court never got to. If it does, what does that do with respect to the class claims? So the first issue was sort of in the ether in this Genesis healthcare case that the court heard in 2013. In that case, the plaintiffs had conceded that the offer did moot the individual claims, and so the majority in that case never got to the issue. The dissent, however, did. Justice Kagan wrote a dissent in that case for 4 justices saying it does not moot the case, and what happened was after that decision came down, the courts of appeals cited to the Kagan dissent and went in that direction. And so in Campbell-Ewald, the court is back to the same issue. We already know there's 4 votes favoring that result, and the real question was whether Gomez was going to be able to get a 5th vote. Spoiler alert, he did get a 5th vote. Justice Kennedy joined the majority opinion. Justice Thomas also went that way, but for a different reason, had his own opinion concurring in judgment. And what the court held with respect to that is an offer is just that, it's only an offer. Once the offer is rejected, there's nothing left on the table, so the case or controversy remains and the case can go forward. I'm going to talk a lot more about that in a second, but let me just tell you what the court said with respect to the second issue. So the second issue is this derivative sovereign immunity issue. It's gotten very little attention, I personally think surprisingly little attention. The court, I think, either didn't ask about it at all at oral argument or maybe had like one question on it. And the opinion kind of gets in and out of it pretty quickly at the end, but it does at least three things. One is it makes clear that there is such a thing as some sort of immunity for government contracts that may be applicable in certain cases, may be available in certain cases. Number 2, it gets rid of this distinction that the Ninth Circuit had made. So the last time the court had talked about derivative sovereign immunity was in 1940 in a case called Yearsley. Yearsley, is not the easiest case to read. It's not, if I remember correctly, I don't even know if it uses those words, derivative sovereign immunity. So there was a lot unsaid by the court in the intervening, 70 plus years. The Ninth Circuit had taken Yearsley and constrained it to its facts and said it was a case involving public works projects. That's where it applies. It doesn't apply outside of that context at the end. So the court very quickly in a footnote says, no, that makes no sense at all. So we know it's not limited in that respect, and we know that there was no immunity here. What the court said is Campbell-Ewald was not entitled to immunity, both because what it did violated federal law and because it violated the explicit instructions of the government to only send the text messages to those on the opt-in list. So those are the court's 2 holdings. Let's go back to the first issue and talk about what I sort of referenced in the beginning, which I think is a potentially really large silver lining here. And so the court left open a very big question in this case. There was an argument that, okay, so this is an offer. The problem with an offer is once it's rejected, there's no legal obligation on the part of the defendants to actually pay the plaintiff's money. So if the case is dismissed as moot, the plaintiff gets nothing. So what if instead of just offering relief, the defendant writes a check, deposits it in an account with the plaintiff's name on it, payable to the plaintiff. So there's not just an offer of payment, there is actual payment. What happens then is the case moot in that case. And what the majority said is, we're not answering that question. It's a question for another day. And so we'll wait and see what happens. The dissent picked that up, and it's quite clear, obviously would have agreed with Campbell Ewald in this case, certainly will agree that that's sufficient to moot the case. And so, in the next run, the question is whether the dissent can get the extra votes to have that make a difference in terms of the outcome of the case. And so what is unsurprisingly happening right now, and I think what will continue to happen, is the defense bar is taking the next step and saying, okay, fine, here's the statutory damages, I'm giving you everything you asked for, it's in an account in your name, or I'm depositing it with the court, whatever the actual technicalities of that process are. Now that you have the money, there is nothing left for you to fight about. So that issue is undoubtedly going to work its way back through the courts. I think this will be a trilogy. I think there will be a round 3 at some point in the future, probably not in the all too distant future, to see where the votes shake out with respect to that issue. If that is a solution, it's a huge deal for the defense bar, because it allows them to address the actual harm caused in these individual cases by paying the individual plaintiffs, and it takes away the leverage that the plaintiffs' class and plaintiffs' lawyers have in these, gigantic class action contexts where there could be a huge damages award at stake, and that offers not only really offers plaintiffs' attorneys sort of a big dollar figure if they're successful in urging settlement in these cases. So we'll see what happens in that respect, and where the lower courts, and also where the court ends up on that issue. But I think there is potentially sort of an easy way to get to the same result in this case. Now, just one caveat there, this only works in certain types of class action. It only works in cases where the complete relief is sort of readily ascertainable, where there's a fixed damage amount, statutory damage cases. And it only works in cases where it makes sense for the defendants to actually pay the amount that the plaintiffs are asking for. So in instances where either it's an uncertain amount or where it's a really high amount on the individual plaintiff side, this strategy really isn't going to do all that much work. But for cases like the TCPA cases, I think this is where we're going next. Now, derivative sovereign immunity, a word on that, because I actually do think it's a big deal as well. I think it's sort of a potentially sleeping giant, because the court hadn't said anything about it in a very long time. And I think it is something that's relevant to government contractors. There are military contractor cases that have been going through the courts involving actions in Iraq and Afghanistan, issues related to derivative sovereign immunity. Sometimes that's baked in, sometimes it's in terms of preemption, have gone up to the court, I think at least 3 times in recent years. I think every time the court has asked the Solicitor General for his views, the SG's office has said no, deny for the following reasons. The court has so far followed that path, but those cases are still sort of percolating in the lower courts, and what the court has had to say here in the derivative sovereign immunity context, granted, leaves a lot more questions, I think, than answers, but I think we may see that doctrine fleshed out a bit more in the lower courts in the years to come, and maybe at some point in a case where that is the only question presented, the court will have more to say about it. In this case, there was sort of a lot to conquer, and on 2 really very different issues. It's pretty rare to see that. So those are my sort of takeaways on that. Greg talked about the other class action cases that are currently pending before the court. One may wonder what impact what the court did in Campbell Ewald, what it sort of says with respect to the other cases. I mean, I think interestingly, you can read Campbell Ewald as a pretty narrow opinion. It sounds like Tyson's Foods may be headed in a similar sort of more narrow direction. And so, maybe there is something to the idea of, in instances where the class action plaintiffs prevail, maybe they prevail only narrowly. We'll obviously wait and see what happens to that. As far as the Microsoft case goes, I mean, it's sort of an interesting flip side to Campbell Ewald. You could look at Campbell Ewald and saying you're sort of using jurisdictional doctrines to get to a result that gets class actions out of court. You could look at Microsoft as a way that the plaintiff's bar is using jurisdictional devices to get class actions back into court, or at least up on appeal. And so we'll obviously see what the court has to say about those 2 cases. The other cases I was going to talk about, and I'll try to get through them a little bit faster because they have not been decided, so a lot more speculation on them. are the IP cases for the term. So there's 3 of them this term, 1 copyright, 2 patent cases. The court's been taking a lot more, especially on the patent side, cases in the sort of preceding years, so 3 is not a terribly big number, especially since only 2 of them are patent cases. And the court has been reversing the Federal Circuit a lot on the patent side of things, certainly not always, but when it takes a Federal Circuit patent case, there's always a real question as to whether the Federal Circuit doctrine, which sometimes has been longstanding, whether it holds up in the court. So let's start with copyright. The Kirtsaeng case is a good transition from Campbell Ewald because it's another rerun case for the court. This is the second time the case was before the court. The first time it was before the court, I was in the SG's office and I worked on the case, so full disclosure on that. We lost, meaning the government lost on that issue. What happened there was Kirtsaeng basically was importing textbooks, foreign textbooks from overseas at a low cost because they're sold lower cost overseas, and was reselling them in the U.S. for a profit. John Wiley and Sons sued for copyright infringement, and the issue was the first sale doctrine in copyright law, and the question was, when the article is manufactured overseas, does that trigger the first sale doctrine, or is it limited to products that are made in the United States? That was also a repeat issue. The court had taken the exact same issue in 2009 in a case called Costco versus Omega. It split 4-4, and so waited a few years, took the same issue, and this time came out 6-3 in favor of Kirtsaeng's position that even if the product's manufactured overseas, it triggers the first sale doctrine. You can do with it what you will, which is overstating, but that's basically where the court came out on it. So now the case is back. Kirtsaeng went back to the district court and said, okay, I won. I want my fees. I want attorney's fees. And that made its way back up. The district court in the Second Circuit said, no, among other things, the position was clearly, the other side was clearly objectively reasonable. I mean, after all, it went up to the court twice. The court divided on it. We don't think, you're entitled to fees. And so the issue in this round is what the standard is for awarding copyright attorney's fees in copyright cases. And this is Section 505 of the Copyright Act. The court last sort of considered attorney's fees in this context, I think it was in 1994. The issue there was whether it should be the same standard when the plaintiff prevails as when the defendants prevail. The court said yes. It also listed a number of factors that courts could look at. According to the petition in this case, what's happened over time is the circuits have applied sort of different variations of the test, looking to different factors, giving weight to different factors, maybe giving presumptions here or there. And so really the petition calls for the court to step in and provide clarity, so you end up with the same result or at least a similar result in different circuits. So, we'll see what the court does with respect to that. The argument hasn't been scheduled yet. It was just granted a couple weeks ago. A few notes on this one. There are interesting sort of parallels to patent law. One of the arguments made in the petition is that in the patent law context, the court talked about attorney's fees recently in Octane Fitness and Highmark. And in the patent law context, what the statute says is attorney's fees are available in exceptional cases, and the argument made is that the Second Circuit essentially is applying a patent law standard in the copyright context, and the copyright statute is not so limited, isn't limited to fees in exceptional cases. Interestingly, and this is a little bit of a side note, but I think an important one, the original issue in Kirtsaeng, the first sale issue, also comes up in the patent context. And it's called patent exhaustion, in that context. And there's a case right now pending in the Federal Circuit. They had en banc review of the issue, basically of whether the same rule in Kirtsaeng should apply to patent exhaustion. It hasn't in the Federal Circuit. The court in Jazz Photo, many, many years old, has always applied a different rule. The court took the case en banc. It was argued in October. And at some point we will see whether the Federal Circuit reverses course. I think that's a case that's likely, depending on how the Federal Circuit comes out, or maybe either way, I think is probably likely to be before the court fairly soon, maybe next term, if not the term after. Halo and Stryker is the next case, IP case. It's a patent case. As well, this one doesn't involve attorney's fees, but it does involve enhanced damages, which is sort of a neighboring statutory section to the patent attorney's fees provision. And the arguments in this case piggyback a lot off of the court's decision in Octane Fitness and Highmark decided in 2014 that dealt with the attorney's fees provision. In this case, the patent statute provides for the district court to award enhanced damages up to 3 times, so up to treble damages in certain instances. And the real question is sort of what instances can enhanced damages be awarded? What test should be applied? Is it a rigid test? Is it a flexible test? The Federal Circuit has applied what some have called a rigid 2-part test that looks to objective recklessness and has basically said in circumstances where the infringer has a reasonable defense, even if it's not a successful one, you do not get enhanced damages. So that issue is kind of at the crux of the case. The SG has filed a brief supporting petitioners in this case, and the government's position is that, yeah, it has to be pretty egregious misconduct, but there's no reason to limit it and to not permit damages in circumstances where there's a reasonable but unsuccessful defense. We'll see what the court does with respect to that. If you look to Octane Fitness, they have had a bit of a practice of getting rid of rigid rules. I mean, even if you look as far back as what the court did in eBay, getting rid of rigid rules and applying sort of general doctrines. That's not quite totality of the circumstances, but that's what it did more recently. So we'll see what the court does with that. There's sort of 3 issues baked into the case. One is what the standard is that applies to enhanced damages. Another is what the standard of proof is. The Federal Circuit has been applying a clear and convincing evidence standard. And another is what the standard of review is. The Federal Circuit has been applying a de novo standard. These are repeat issues, again, from the attorney's fees context. And so, one of the main questions is whether the court's going to follow what it did there or whether there's something different about enhanced damages that you would expect a different result. Some of the judges on the Federal Circuit kind of urged the court, like, let's look at this, our doctrine again in light of these recent Supreme Court cases that, didn't happen, and we'll see what the court does with that. It's being argued soon, so we'll know we'll at least be able to read the tea leaves from argument on February 23rd. And if petitioners prevail, I think we'll see maybe a little different landscape on how often people ask for enhanced damages and how often they are given enhanced damages and to what extent that's changed in the attorney's fees context post-Octane Fitness. Apparently, there have been many more grants of attorney's fees. Yeah? Time? Okay. Do you want me to skip Kuzo or?
Why don't you skip that for now?
Okay.
We can come back to that if we have additional time.
All right. It's a big one. We'll talk about it later.
Ashley?
Thank you very much. It's also very nice to be here. What I want to do this morning is say a few words about the court's administrative law docket and how it's handling administrative law cases. I think this is appropriate for a number of reasons. One is that there seems to be, particularly last term, a number of important administrative law cases that the court is granting, and again this term. What we see is not particularly aggressive moves by the court to actually discipline the government or the agencies, but we also see, sort of particularly in the concurrences and dissents, an increasing interest among at least some of the justices about revisiting some of the foundational questions. So last term we see Justice Thomas raising the question as to whether Chevron is actually constitutional at all. What I want to do is start with that, mention what I think are 4 key themes that we can see percolating through these cases, and then I want to look at those themes through 2 of the energy cases that I was involved in this term, and then also 3 other cases, 2 which are before the court and 1 which is pending, that are all raise interesting issues. So the 4 themes. The first one is textualism versus dynamic interpretation. This comes up repeatedly. The question is that when circumstances change and you have an old or an older statute, who gets to update that statute? Is it the agency, is it the court, or is it Congress? And perhaps the sort of highlight of this debate among the court was seen 2 terms ago in the UARG decision, which was a question relating to EPA's authority under the Clean Air Act to regulate greenhouse gases. Justice Scalia's majority opinion applies textualism and says, look, we are not going to sit here and let EPA rewrite the statute. What EPA wanted to do was change the statutory thresholds, basically write them out of the statute and come up with its own statutory thresholds. And so Justice Scalia at least put a marker down for textualism that said, these types of changes have to be done by Congress. They can't be done either by the court or by the agency itself. What was remarkable, at least to my mind in that case, was Justice Breyer's dissent. You would think that a statutory threshold, an actual number written in the statute, would be something that could not be changed. But Justice Breyer embraced a very aggressive form of dynamic interpretation, which says, no, you really need to look at the purpose of the statute, and if the purposes are served, then the agency should get lots of flexibility in terms of how it implements it, including reinterpreting statutory thresholds. Second thing I think is really key, and I mentioned this before, is this whole question of deference. It comes through particularly in Chevron deference, but you also see it in subsidiary doctrines like our deference, which is one of the issues before the court potentially this term. The court is really grappling, when does it apply and who should apply it? We saw a couple or 3 terms ago the City of Arlington case, which might have been the high watermark for Chevron deference, that made the point that is when it comes to jurisdictional determinations, that's treated just the same as anything else under a statute. Agencies get deference in interpreting the scope of their jurisdiction. And yet, at that time, everyone would have thought that means that Chevron is in ruddy good health, but it doesn't look to be that way anymore. In a series of cases, including cases this term, the court seems to be stepping away from Chevron in interesting and important ways. Third is federalism. This question, particularly as federal agencies continue to expand their powers, it almost inevitably comes into conflict with the exercise of the state's traditional authority. And the question is, what does that mean? And I really think that the real question is whether the court sees issues of state authority as being a check and a reason for transparency. One regulator gets to regulate or it doesn't, or whether it really sees this as being a sort of cooperative federalism where all regulators get to regulate. So in that sense, is federalism a check, or is it just a way to suggest that there are overlapping powers? And then lastly, I'd sort of throw out this question as to when we take a look at these issues in these cases where agencies are being questioned for their assertions of authority, is there doctrine with teeth that is being developed, or is it just sort of an occasional hall monitor where the court steps in? And I think this is really an interesting and important question, particularly in the administrative law context. Are the cases being driven by really extreme positions? You can think of the Sackett case a few years ago where 9-0, the court steps in and says, we're not going to allow this to happen. Or is it a case where there's nothing else that goes beyond this? Or is the court actually slowly developing doctrine that can trickle down to the lower courts and actually serve as a check on agencies in a meaningful way? So as I mentioned, I want to talk about those 3 themes, particularly by looking at the 2 energy cases. Full disclosure, again, I've been involved in both of these cases. The first case I lost. The second case I wrote an amicus brief, and we'll see if we can do a little bit better there. These are the EPSA v. Ferc case and then the Hughes versus PPL Energy Plus. And then I want to briefly mention these 3 other cases that are on the court's docket or asking for the court for review. The one is the U.S. Army Corps versus Hughes case. That's really Sackett 2. When is U.S. Army Corps engineering jurisdictional determinations final and right for review? The second one is the United States versus Texas case. That's the immigration case, and the question, it has a lot to do with constitutional issues, but lurking underneath it in a very important way is a question of when do agencies have to go through notice and comment rulemaking. And then lastly, United Student Aid Fund versus Bible, which raises the question of whether the court will get rid of our deference altogether. Our deference being the idea that an agency gets deference for its interpretation of its own regulations. So again, let me start with the EPSA v. Ferc case. It's a technical energy case, but it raises these themes in sharp relief, and I want to see if I can quickly explain to you what the case is about. So the Federal Power Act has always divided jurisdiction between the federal government and the states. States have exclusive jurisdiction over the regulation of retail sales and rates, and the federal government has exclusive jurisdiction over the regulation of wholesale sales. As a result of this division, there is always inefficiencies. Obviously, wholesale markets and retail markets are connected, but because they're regulated separately, when prices in the wholesale market fluctuate, which tends to happen competitively on an hour-to-hour basis, prices in the retail markets don't. Those tend to be much more static, and so they don't adjust as quickly. That causes inefficiencies, so there can be situations where retail customers continue to consume energy even when prices in the wholesale markets are high and would suggest that they shouldn't consume so much. So FERC adopts what is known as the regulation of demand response. Demand response is a clever term, but what it really means, and as FERC has defined it, it is paying retail customers to reduce their retail purchases for the purpose of reducing overall level of retail sales during certain periods. So you can think if wholesale markets go up, and you don't want the retail customers to consume so much, what you do is you pay them, you give them a demand response payment for committing not to consume energy at that time. The question in the case, at least the jurisdictional question in the case, was whether or not FERC regulating that was impermissibly regulating retail sales, or whether it was consistent with its authority to regulate wholesale sales and practices affecting those wholesale sales. In late January, so the D.C. Circuit struck down the FERC's rule as being in excess of its jurisdiction. In late January, the Supreme Court reversed in a 6-2 decision with Justice Alito recused. What is interesting about Justice Kagan's opinion is to look at it through those themes that I mentioned earlier. Of course, I'm a little biased because of my position on the case, but I also think this is sort of actually very helpful. So first start off with dynamic interpretation. She embraces a very dynamic interpretation of the statute, very similar to sort of Justice Breyer's dissent from a few years ago. She starts off by saying demand response is very important, it's a beneficial thing, and so it's a good thing, and we should think that the agency should have authority. When it comes to the statutory question, she actually does not address the key question in the case. She explains why why this demand response program doesn't regulate retail rates, because it actually doesn't change the rate itself. And she explains why it was okay for FERC to do what it did, because what it was doing was the payments were occurring in the wholesale market. But there's nothing in the opinion that actually addresses the statutory question, which is whether or not this is actually a regulation of retail sales. That question, the lower court in dissent, Judge Edwards had addressed by saying, well, this is not a regulation of retail sales because you're paying customers not to engage in sales, so it's actually the regulation of non-sales. That's a difficult argument to maintain, but at least it's an argument that addresses the statutory question. The Supreme Court doesn't address that at all and just ignores it. Also, what's interesting is Justice Kagan's majority opinion flips a presumption that has long existed, particularly in energy law, but obviously in administrative law more generally, which is to say that usually the need for regulation alone is not enough to justify regulation. You have to have a grant of authority. The majority opinion says that in the Federal Power Act, Congress basically flipped that because it intended to fill a gap, and when it filled that gap, it actually filled all gaps. And so if there's a need for regulation, there must be somebody who can regulate it under the Federal Power Act. Now, in addition to being what I think of as sort of dynamic interpretation, it is also interesting that neither the majority decision nor the dissent talks about Chevron at all. There's a footnote in the majority decision that says we will not give Chevron deference because the statute is clear. One of the reasons why I think that is interesting is at argument it really looked like it was going to be a 4-4 split, and both the Chief and Justice Kennedy joined the majority opinion. At least with respect to the Chief, I think some of that might have had something to do with the fact that the decision was made not on Chevron grounds, but as an exercise of the court's authority. If you think about that in terms of the city of Arlington from a few terms back, talking about how jurisdictional questions are within the agency's bailiwick, it's sort of interesting that in this case, which really goes down to jurisdiction, no mention at all of the traditional Chevron doctrine or any attempt to sort of think about whether the agency's interpretation is relevant or not. It just doesn't matter. And then lastly, on the federalism point, what this case means in terms of the separation of powers. So the Federal Power Act has always been somewhat of an oddity among statutes because unlike many of the New Deal statutes that have always embraced cooperative federalism, the Federal Power Act has always been interpreted as having exclusive spheres of jurisdiction. There is a real question now after this decision as to whether or not those exclusive spheres still exist. So the decisions until now have always talked about a bright line between federal jurisdiction in the wholesale markets and state jurisdiction in the retail markets. The real question is whether or not that line exists anymore. If it doesn't, it's going to be a huge disruption and lots of litigation in the energy industry. That question actually takes us to the Hughes case, which is the second energy case that the court has right now. The Hughes case almost presents the exact flip question of EPSA. So in the Hughes case, states, in this case Maryland and New Jersey, are concerned about creating proper incentives for generators to build more generation. Everyone agrees under the Federal Power Act that the states have exclusive jurisdiction to regulate the construction of generation facilities. But what they've done here is they've tied that to payments that occur in the wholesale market. So you will get a guaranteed payment stream provided you bid into the wholesale markets and your bid is accepted. If that happens, then the state will provide a sort of a kicker, an additional credit on top that will ensure that you get paid at a guaranteed level as opposed to what the wholesale market is dictating. And the question in that case is whether or not that violates the state's jurisdiction and intrudes on FERC's jurisdiction. If you look at the EPSA case, there's language that goes both ways. One way of reading EPSA would be to say this is exactly the reverse of what FERC did there. All that's happening is the state is using its authority in the retail markets, and the fact that it actually has some impact on the wholesale markets doesn't matter. Another way of looking at it, though, would be to say that EPSA isn't that broad, and what EPSA is really doing is talking about the scope of FERC's authority, which may be broader than the state's authority. I think this case will be argued at the end of this month. It is a very important case. If the court goes ahead and reaffirms the bright line, then I think the disruption from EPSA will at least be contained. If it doesn't, and it goes ahead and says that states can regulate so that the Federal Power Act is no longer exclusive spheres of jurisdiction, but truly the cooperative federalism that you see in some other statutes, I think we will see an explosion of litigation and we'll see lots of disruption in the energy markets. Now, I mentioned that there are three other cases that I wanted to talk about that all raise interesting questions of administrative law. I'm going to blow by these very quickly, but I'll just tell you a little bit about each of them. So one of them is the Hughes case. That's the U.S. Army Corps versus Hughes. It really is Sackett too. So in the Sackett case, the question was whether or not a compliance order by EPA by the Army Corps could be reviewed. Sackett by EPA could be reviewed. And the answer in Sackett was yes, because what you can't have is sort of a compliance order out there and then have the party who's subject to the compliance order build up all these fines and then just wait until an enforcement action is brought. In this case, the issue is that the Army Corps often makes jurisdictional determinations where it says, yes, your land is a wetland, it contains navigable waters of the United States. That has huge implications for business and industry, because once that determination is made, then the question is you have to say, well, do I go ahead and go through the expensive permitting process, or do I subject myself to fines? The question in the case is whether or not that type of guidance that gets provided by the Army Corps is reviewable or not. It's important, obviously, on its own terms, and because questions relating to the Clean Water Act and the scope of the Army Corps jurisdiction is critical in many cases, but it also has broader issues as to what exactly do guidance documents mean, when can an agency use them. Going back to my mischief point, one way to look at this case is an agency that is trying to help regulated parties. It would create a huge administrative burden if every time the agency said, yeah, we think we have jurisdiction, if it had to litigate. Another way of looking at this case is complete mischief by an agency that uses these jurisdictional determinations as a way of forcing regulatory change without actually having regulatory authority in the first place. It'll be very interesting to see how the court divides those issues. The next one is United States versus Texas, which is the immigration case that many people know about. Can the administration, by executive order, essentially bring a bunch of immigrants by category into a particular status where there will be deferred action? Can they exercise the discretion not to prosecute on sort of a categorical level as opposed to a one-off level? When they do that, it means that the immigrants who have deferred action have a lawful status and therefore become entitled to benefits under Social Security, Medicare, work permits, and things like that. This raises another interesting question, which is whether or not the agency needed to go through notice and comment rulemaking in order to make these changes. Again, very interesting. There's a lot of issues in this case. Rich Sant from WLF has just written a very good blog post on this in a symposium by the SCOTUS blog, and I'd recommend that you read it to get a better idea of the issues. And then the last case that I mentioned is the United Student Aid case versus Bible. This case has not been accepted by the court, but it's a petition for certiorari is pending. The question in that case has some technical issues relating to what happens when a student gets a loan, defaults on the loan, and then what costs can be applied to the recovery and the process by which the loan is paid back. I haven't really paid much attention to the facts, because the only real issue in the case that's important is that the case turned in the Seventh Circuit. It was dispositive on an amicus brief that was filed by the Department of Education that said, here's how we interpret our own regulations. And that interpretation seemed to be somewhat adventuresome interpretation of what the regulations require. And the question is under the court's decision in Auer, does the agency get deference for that or not? Now, the petition asks the court to go ahead and just flat out reverse Auer. And there's an interesting brief that's been filed by Professor Hamburger, written by Washington Legal Foundation, that makes the argument more broadly that there should be no deference at all in these circumstances, because it's almost a due process violation. You cannot, most of these cases, not this one, but most of these cases, the deference is given to the agency as a party. And is it really fair to be allowing one party to sort of get a heavy thumb on the scale in their favor on these disputes? Shouldn't the courts, thinking back to Marbury versus Madison, be exercising their authority to be interpreting the law and not deferring to an interpretation by one of the parties? So all very interesting cases. All of those cases could be very explosive. Let me just close with sort of three thoughts that tie back to some of the themes that I mentioned. One is that the government's position in these administrative law cases increasingly is really remarkable. And I think part of this has to do with the Solicitor General as a strategy matter, but also part of sort of a question of how the federal government works, which is almost every argument is that there are no limits at all. It isn't that there are some limits and we're acting within those limits, but basically, court, go away, there are no limits. What's interesting about that position is that it's actually a very successful strategy. Even though that argument leads the Solicitor General's office to be often in an uncomfortable position on the podium, more often than not, the position prevails as opposed to losing. One reason for that is, particularly in these administrative law cases, there is a reliable 4 votes in favor of the government in every single case. And there are 5 votes that are absolutely all over the map depending on the case. So trying to get together a 5-4 split means that it's very difficult to predict how these cases will be decided and where the cases will go. And then lastly, I'd like to say that I think that, going back to my point, is this going to be one-offs or a developing of doctrine? I think that there is a real interest to try to develop doctrine on the court and to watch things move forward. But because of the other observations I made, I think these doctrinal developments will be very slow. They will be incremental, and they will be around the edges. I think it will be interesting to see if we see the type of sea change that Justice Thomas is calling for, but I personally believe, although that would be sort of a welcome change in some of these cases, I think it's very unlikely to happen. Thank you all very much.
Thank you very much, Ashley, Melissa, Greg. I think we have time for just a few questions. So if we have questions from the audience or online, or among the panelists here, if we have questions or comments.
I'm Kenneth Jost with Supreme Court Yearbook and my blog, Jost on Justice, Mr. Parrish. It's been reported that the Supreme Court's stay, 5-4 stay in West Virginia versus the United States is, quote, unprecedented, close quote. Is it in fact unprecedented for the Supreme Court to stay a regulatory order in advance of any merits consideration by a lower court? And if so, what does it mean? And does it tie in with the themes that you were just describing?
So let me answer your second question and admit ignorance on the first. I know it's very unusual. Whether it's unprecedented or not, I can't tell you. I do think it goes into the theme. So one argument, whether this is true or not, is that there have been huge problems with procedural maneuvers by agencies that allow them to win by losing. So you see that both in terms of the vacatur and remand rules that occur in the courts below, where a regulation will be struck down, but then it won't be vacated, so it just remains on the books until the agency takes the next steps. You've also seen it with this idea that they know that litigation takes so long, so strategically it's better to take an aggressive position and be pulled back a little bit than it is to take the right position and then be pulled back further from where you'd want to be. I think that if this had happened 2 years ago, I think the stay would have been denied, and I think that there's a good chance that the case would have gone forward. What happened here is, going back to my theme about mischief versus doctrine, is that I think the court was persuaded by the fact that the last big EPA case that came up here, EPA made the mistake of, when it went back on remand, trumpeting the fact that it didn't make any difference what the court had said at all, because already the programs had already been implemented and it was just all too late. And the West Virginia and the other parties that sought the stay really emphasized that point. It was a very powerful part of their stay request, and I think it influenced the court. The big question, though, is that this is one of these areas where a lot of doctrinal reform would be very helpful, but I don't think that there's going to be an opportunity or a likelihood that the court's going to weigh in, so it's more likely to be a one-off, unprecedented type thing, as opposed to suggesting a shift in any way in terms of how these things are handled.
Melissa, I'm going to give you the chance to talk about Quozo. Okay. First, why is it an extremely important case? And second, is there somewhat of a split within different industries as to how they hope the case will come out? It seems at the cert stage only sort of one type of patent holder was filing in support of cert.
Yeah, so it's, let me start with the first question. I mean, it's a big case. It involves IPR proceedings before the PTAB, which is something that sort of came into being in 2011 in the America Invents Act. And it's a big one for a number of reasons, one of which this is the first time the court's looking at these IPR proceedings. And in the proceedings, third parties are able to petition the PTAB to have patent claims invalidated on one of two grounds, novelty or obviousness. A lot individuals have taken, or companies rather, have taken advantage of these proceedings, and a lot of patents have been invalidated as a result. The issue here has to do, at least the first issue has to do with the standard that the PTAB applies in these proceedings. It applies a standard that is different than the standard applied in district courts who are reviewing validity decisions. And it's one that tends to lend itself towards invalidity determinations more so than what happens in district courts. And the Federal Circuit in general has been deferring a lot to PTAB. And so when by taking this case, we'll see sort of where the court is on this new animal. We'll see whether it thinks the same standard should be applied as district courts. If it does, I think fewer patent claims will be invalidated through these proceedings, and maybe less people will avail themselves of this sort of forum. One may say, a forum shopping alternative in some ways, and in terms of deference to the PTAB, that with respect to the Federal Circuit, that could change as well. And so there's a lot to sort of be seen in terms of where the court ends up on this. The one side thing, there's arguably a lurking bigger issue here with respect to PTAB. There's a cert petition pending that was just filed last month in this case called Cooper v. Lee that raises a constitutional challenge to the PTAB proceedings on Article 3 and 7th Amendment grounds. The Cooper petition is based on a decision of the Federal Circuit in this MCM case that was decided in December. Their petition wouldn't be due, I think, until March without extension. And so sort of depending on what the court does in Cuso, there may be a bigger question in terms of the constitutional validity of the PTAB proceedings that could have a huge impact. Now, as far as where people are on where different industries may be on this, I think your intuition is probably pretty sound. I mean, we'll see what happens. Nothing's been briefed yet, and at the cert stage, the general rule is you come in if you support the petitioner, you don't come in if you support the respondent, because that doesn't help your case in terms of getting the petition denied. So it'll be really interesting to see who files and on what side on the merits stage. But as in a lot of these sorts of cases, I imagine there will be a division among industries in terms of what side people come in on. I mean, it depends very much on whether you view the IPR proceedings as a positive development or as something that is that is negative and sort of is to be avoided at all costs.
My question is for Greg. Going back to the RJR case that you started with, you mentioned that there's both a civil aspect to RICO and a criminal aspect to RICO. Do you think that the court will reach the question of whether a sort of rule of lenity should apply in the civil situation, given that the statute really needs to be interpreted the same way in the civil and the criminal context? Or do you think it'll stay away from that issue?
I hesitate to make predictions. I can tell you that wasn't something we pushed aggressively. I mean, the civil criminal line that we tried to really exploit is to say, look, there is this separate civil provision, and you have to separately apply the presumption of extraterritoriality to the civil cause of action, and that pretty straightforwardly means you need a domestic injury. And that's really how we're pressing it.
I have a couple questions for Greg. Just looking at the implications, both on the RJR Nabisco case and then on the McDonald case. On RJR Nabisco, what's your sense about how the outcome of this case would impact the position of competitiveness for U.S. business in a global economy? And I guess related to that is this sort of is the case here an effort to end run the Alien Tort Statute? That's the first question. Why don't you answer that?
Okay, yeah,
There's two questions.
I think the second question answers the first, which is if we lose this case, then RICO becomes the Alien Tort Statute version 2.0. You all, I'm sure, know the Keeble history. American corporations do business abroad in parts of the world where standards of conduct are not quite what they are in this country. And the Alien Tort Statute is this very broad potential entry point into U.S. courts, picks up anything that could be characterized as violation of the law of nations, and the court tried to restrict that, but lots of opportunities to make creative theories about what constitutes a violation of the laws of nations, and then you have these sort of theories for tying American corporations to the misdeeds of other people abroad. So you have an aiding and abetting liability theory, and all of a sudden, when Chevron is doing business in Nigeria and either economically motivated plaintiffs' lawyers or ideologically motivated human rights lawyers don't like what's happening in Nigeria, they gin up some theory that, well, Chevron is really aiding and abetting the human rights abuses. It's a very easy thing to do. And Keeble stops that by saying Alien Tort Statute doesn't apply extraterritorially. But think of RICO. RICO has the same quality to it. It's a potential entry point for anything, basically two criminal acts that occur within 10 years and are related. So same situation, you're Reynolds, you're doing business in Europe, and so instead of saying, well, you're aiding and abetting human rights abuses, they say, well, your business partners are unsavory, so the transaction with your business partners is money laundering. And then the money laundering predicate applies extraterritorially. Not a huge problem on the criminal side because the United States controls the prosecutions, and the United States never saw fit to prosecute Reynolds and Philip Morris and Japan Tobacco and every other company for supposed money laundering. But private plaintiffs don't have that incentive, so they can bring creative cases like that predicated on money laundering or who knows what. Lots of criminal statutes apply extraterritorially, so it really is a roadmap for bringing similar kinds of cases against similar kinds of defendants with similar economic or ideological motivation on the plaintiff's side of the V.
The second question, maybe it goes, Greg, given your platform as having spent considerable time at the Justice Department in senior positions on the McDonald case. One could look at the McDonald case and say bad facts make bad law, and that may be the end of the case. Or you could look at it and say this is an interesting confluence of some significant issues as to prosecutorial discretion, power of the state versus the individual, over criminalization of our political process. As you articulated some of the issues in the case, and I'd like your reflections perhaps on the implications of that, if the court were not to adopt a position where you need some kind of bright line official government decision making that constitutes the quid pro quo, what are the implications of that for our political process and for the ability of, whether it's the Justice Department or the government, to sort of criminalize a lot of activity in the political process?
So I'd be very surprised if the court follows the line drawn by the Fourth Circuit, which is official act just means anything that government officials do. I think the consequences, for the reasons I tried to lay out, are pretty staggering, right? It's any donor, any politician who takes campaign contributions, or any private citizen who gives campaign contributions. If that person gets any routine, now ubiquitous courtesy in exchange, whether it be a night in the Lincoln bedroom or the retreat with the senators, or something less dramatic than that. You get the senator sends you a book or something. That's potentially a felony. That seems to me, that's sort of the attempt to kind of undo Citizens United by this kind of freakishly expansive definition of official act. If the court reverses and says no official act means something more than that, I think then you'll probably have follow-on cases in which they have to address the nitty-gritty of what's the line between official and what's not, and there may be close cases, but this would not be a close case if you have some conception that official act means an exercise of governmental power.
I don't know if we have time for one more question. If there are any other questions online. If not, Ashley, Melissa, Greg, thank you very much for joining us, and thank you all for joining us today for this Washington Legal Foundation program on the High Court at Midpoint at halftime. We look forward to meeting with you.